the other hand, the Appellant's Counsel submitted that this is a sui generis appeal, as it is neither criminal nor civil in nature. It largely relates to interpretation of various constitutional and statutory provisions, and therefore we have no jurisdiction to entertain it as a civil appeal, even if the initial case before the trial court is a criminal case and the matter before the High Court was instituted as criminal revision. We must ask ourselves, how then did the case metamorphose from a criminal matter to a civil one? Why was it not filed as a criminal appeal, as in the case of Thomas Patrick Chomley? We do not have any answer to these questions, and neither did the Appellant's Learned Counsel shed any light. While we do not encourage this kind of practice, we note that the Supreme Court stated in the case of Dines Mureithi and 4 others versus the Law Society of Kenya that appeals dealing with constitutional issues may in substance be civil in nature. Further, we think that to decline jurisdiction and strike out the appeal simply because it was not instituted as a criminal appeal would be tantamount to summary rejection of the appeal on a matter of form rather than substance, which would be contrary to the spirit and intent of Article 159 2D of the Constitution. On the question of denial of access to his office, did it amount to removal of the appellant from office? The trial magistrate held that barring the appellant from accessing his office neither violated the Constitution nor amounted to his removal from office. It was only, I quote, intended to ensure the integrity and credibility of this trial and to ensure the public interest is safeguarded, end of quote. The learned judge concurred with the trial magistrate. We have already quoted her sentiments on the issue. On the other hand, Professor Ojienda argued that the learned judge's holding amounted to a constructive removal and or suspension of the appellant as the governor of Kiambu County. He cited Black's Law Dictionary, 10th edition, which defines office as a position of duty, trust, or authority for public purpose, a place where business is conducted or services are performed. The same dictionary defines removal as the immediate termination of an office holder's privilege to serve in that office, usually after a vote. Suspension is defined to mean the temporary deprivation of a person's powers or privileges, especially of office or profession. It also includes temporary withdrawal from employment as distinguished from permanent severance. Counsel submitted that the effect of the trial court's orders that were affirmed by the High Court was to occasion an unlawful vacancy in the office of Governor of Kiambu County, which is contrary to the provisions of Article 182(1) of the Constitution. The article stipulates that the office of Governor falls vacant when the holder thereof dies, resigns in writing, addressed to the Speaker of the County Assembly, ceases to be eligible to be elected County Governor under Article 182, under Article 180, sub-Article 2, is convicted of an offense punishable by imprisonment for at least 12 months, or is removed from office under the Constitution. He concluded by saying that there is absolutely no provision of law that empowers a court to occasion a vacancy in the office of a governor through the imposition of bail terms and conditions. The determination of this issue involved interpretation of Articles 49(1)H, 181 and 182 of the Constitution, as well as Section 62(6) of the Act. The learned judge had that in mind and stated, quote, since the Constitution provides for mechanisms of removal or vacating such state officers, no other law would supersede it, end of quote. She then considered the provisions of Article 181 and 182 of the Constitution that relate to removal of a county governor and vacancy that office respectively, and concluded as follows. This court, having aligned itself to the supremacy of the Constitution, holds that attaching conditions to the grant of bail is not tantamount to a removal of the governor from office. We do not think that the learned judge can be faulted for arriving at that conclusion. Article 49(1)H of the Constitution provides that an arrested person has a right to be released on bond or bail on reasonable conditions pending a charge or trial unless there are compelling reasons not to be released. In our view, to the extent that neither the trial magistrate nor the learned judge's holding purported to remove or suspend the appellant from office of governor, Kiambu County, Section 62(6) of the Act had no application in the matter that was before her. The appellant has not been suspended from his office. He's still the governor of Kiambu County. He's still entitled to his full pay, not half. In the circumstances, the learned judge cannot be accused of having failed to apply the omitted case, canon of statutory interpretation, in affirming the terms of the appellant's grant of bail. The issue of constitutionality or otherwise of Section 62(6) of the Act is not before us for determination in this appeal, and therefore we cannot express any opinion on the same. Regarding the conditions attached to the grant of bail by the trial court, the learned judge was of the view that the trial court wanted to ensure that the relationship between the appellant and potential witnesses does not undermine the interests of justice. Article 49(1)(h) of the Constitution grants an accused person the right to be released on bond or bail on reasonable terms and conditions pending trial, unless there are compelling reasons not to be released. The bail and bond policy guidelines formulated by the judiciary require courts in granting bail to take into consideration, inter alia, the facts and circumstances of each case, and to balance the rights of an accused person against the interests of justice. The same considerations are applicable to all accused persons, irrespective of their society in standing, irrespective of their standing in society. In Republic versus Zachariah Okoth Obado, the accused is the governor of Migori County and was charged with murder. Among the conditions for his release on bail were that he shall not go anywhere within 20 kilometers of Homa Bay Migori border. He shall report once a month to the High Court's Deputy Registrar, and that he shall not contact or intimidate, whether directly or indirectly, any of the prosecution witnesses. In the case of the appellant, bearing in mind the nature of the charges preferred against him, the circumstances under which the alleged offenses were committed, that some of the prosecution witnesses are county staff who are answerable to the appellant, it was not far-fetched for the prosecution to contend that the appellant would most likely interfere with their witnesses or conduct himself in a manner likely to compromise their case if he was not barred from accessing his office during the pendency of the case. There are documented incidents of loss and or disappearance of vital documents from certain offices where public or state officers charged with corruption or economic crimes related to their work have been allowed unrestricted access to their offices during the pendency of the cases. Looking at the statutory functions and responsibilities of a county governor, the structure of governance and the legislative and administrative institutions of a county, we do not think the impugned bail terms, unless set aside, are likely to paralyze the operations of Kiambu County, as was submitted by the appellant's learned counsel. The question of whether Kenya shillings 15 million cash bail or bond, or Kenya shillings 30 million with the surety of a similar amount, was harsh and excessive, the appellant argued that the above terms as set out by the trial court and affirmed by the High Court are harsh and excessive, unreasonable, contrary to Article 49(1)(h) and Sections 123 and 123A of the Criminal Procedure Code. The judiciary bail and bond policy guidelines and were fixed without regard to the circumstances of the case and evaluation of the nature or seriousness of the case, the character, antecedents, associations, and community ties of the appellant's record in respect of the fulfillment of obligations under previous grants of bail, and the strength of the evidence of the appellant having committed the offense. The learned judge found the bail bond sums imposed by the trial court appropriate. The learned judge held that the grant of bail by the trial court was an exercise of discretion, and the High Court could only interfere if the decision was shown to be plainly wrong or granted without consideration of relevant factors. The learned judge stated, and I quote, "The court was under a duty to consider the grant of bail for each individual accused person, examine their circumstances before setting commensurate bond or bail terms and attaching conditions. It is trite that the setting of bond or bail amounts is an exercise of discretion by the trial court, and before interfering with that exercise, this court must be cautious, as was ably enunciated by Baroness Hale, as she then was, in the case of Rijay, a child, the case, a 2006 case that stated that if there is indeed a discretion in which several factors are relevant, the evaluation and balancing of those factors is a matter for the trial magistrate. Only if his decision is so plainly wrong that he must have given far too much weight to a particular factor is the appellate court entitled to interfere. Too ready an interference by the appellate court risks robbing the trial magistrate of the discretion entrusted to him by law. End of quote. We respectively agree with the learned judge's holding, and we have no basis of faulting her in any way. In conclusion, therefore, we find this appeal devoid of merit and dismiss it in its entirety. The appellant shall bear the costs of the appeal. It is so ordered.